serving and protecting the unhoused community and those at risk of becoming unhoused. HALT members serve as a core support for the National Homelessness Law Center to achieve our mission of advancing federal, state, and local policies to prevent and end homelessness while fiercely defending the rights of all unhoused people. Our HALT members are instrumental in ensuring that we have the pro bono support that we need for the many cases that we all get involved in ourselves and with our local partners. And we're just really excited to have both HALT firms and other community partners on the call today. At the end of our think tank, we'll have an opportunity to figure out how to learn more, both about the opportunities that are presented today in this presentation, and then also about HALT in general. So I think I was kind of expanding that out as we let a few more people get into the room from the waiting room, but I think we better go ahead and get started. I will turn it over to my colleague, John Salois.
Thanks, Katie. Much appreciated. So good afternoon, everyone. Thanks for joining us today. So this is a HALT training regarding the due process rights of youth in shelter. We're going to be presenting a lot of information this afternoon. So if you have any questions, just put them in the chat, raise your hand, shout them out. Any of that works for me. So the issue I've been researching for the past year and a half is what are the due process rights of youth in shelter and other housing programs. So when we first started this, there was some anecdotal evidence or preliminary evidence that we thought the issue might be pretty widespread, that youth are in shelter and they're being terminated from shelter without a process. And so since the year and a half, we've been looking at this issue. We've noticed that it's two things probably. It's both widespread, but also there are rights that youth can access, and even non-youth, if I'm speaking in the where we're going with this. But for our purposes, for youth, there are rights that youth can access. So I'm going to present a lot of information, a lot of law, a lot of regs, a lot of boring stuff, quite frankly. But then I'm going to pass to my two colleagues, Tori and Liz, and they're going to talk about real world issues, that how this issue is actually affecting their community. So just a little bit about me. So my name, again, is John Salois. I'm the youth shelter and housing attorney. I've been working with youth experiencing homelessness for well over a decade now. Before Law Center, I was working at Legal Counsel for Youth and Children in Seattle. They're one of the largest legal providers for youth experiencing homelessness, not just in the state of Washington and the entire country, actually. And I also was a co-founder and policy director for a small nonprofit in Portland, Oregon, with really the same model. So basically, I'm going to pass to Tori and then to Liz. They can introduce themselves and then we'll get started.
Hi, folks. Thanks so much for joining us today, and thank you to NHLC for inviting me to present along with John and Liz. My name is Tori Dempsey. I am the staff attorney and program director of the Youth and Family Advocacy Program at Legal Services of Eastern Missouri. We're at Legal Aid. My program specifically works with unaccompanied youth, so young people not living with an adult or legal guardian who are typically between the ages of 15 to 19 years old and are experiencing homelessness or are at risk of experiencing homelessness. With my program, we help out with a variety of issues, including housing terminations, with the support of NHLC and John, which we'll discuss more. But we also assist with a variety of civil legal matters, such as accessing public benefits, contracting for certain essential items under Missouri's qualified minor law, since we don't have legal emancipation in our state, and a variety of other matters as well. Happy to be here.
Hey everyone, my name is Liz. I use she and they pronouns, and I am the founder and president of Southern Legal Center for Youth. And I'm based in Atlanta, Georgia, and I'm a 3L part-time at the Georgia State University College of Law at the moment. But for the past 6 years, I've been working in the youth and young adult homelessness space, mostly on the data side. I've written some of the most comprehensive research in youth and young adult homelessness up in Washington State. But my focus here today is really on what we're seeing in the South in terms of young people's experiences in shelter. And I'm really excited to be with you today. There may be some folks from Atlanta in this call who haven't heard of us, and that is because we literally just started, and we started taking clients about a month ago. And in that time, we have prevented 3 evictions, and I'm currently helping a young person get some things off her credit report from when her identity was frauded. So I'm just really excited to be here with you today to make sure Southern Legal Center for Youth is front of mind for you. We are the only and the first legal center of our kind in Georgia who is doing this work with young people aged 12 to 24 and those experiencing homelessness and housing instability. And we're also one of the few legal centers of our kind in the South. So we just appreciate you knowing about us and any support that you can provide us in the future.
Thanks, Liz and Tori. So I just want to say I'm so glad you're with us today, because so I'm looking at this issue from a policy perspective, from a national perspective, but they are wearing like 11 different hats and also looking at this issue. And I just appreciate your work so much, and I can't wait for others to hear what you're doing. So, so the question I always ask when I start these is, what happens if a youth is terminated from shelter? So is there a process? What kind of process? You know, what does an agency owe to a youth who's terminated from services? So, and just as a clarifying point, when we're talking about shelter and other housing options, other housing opportunities, what we're talking about is emergency shelter. We're talking about long-term, can be long-term shelter, transitional living programs, maternity group home programs for parenting youth, programs for youth aging out of foster care, host homes, supervised apartments. So all of the options that youth see when they're experiencing homelessness. All the rules we're going to talk about today, the regs, all of this generally applies to these programs. So the first thing I want to do is talk about due process. Now, most of us are lawyers here, but not all of us are lawyers. And I think it'll help the conversation flow a little better if we just talk about what due process is, because this is basically what the whole presentation is about. So basically, the notion of procedural due process, it derives from the U.S. Constitution, the 5th and 14th Amendments. So both amendments guarantee due process when a person is denied life, liberty, or property. So that doesn't mean the government can't take away a person's life, liberty, or property, but that it can't take those things away without first giving that person a fair chance to defend themselves. So, for example, governments can't imprison someone or take away a person's children without allowing the person to challenge those government actions. So this also applies to property in something we call entitlements that have been bestowed upon the populace. You know, things such as Social Security benefits or other public benefits. And those of us who are lawyers know these line of cases as Goldberg v. Kelly and Matthews v. Eldridge. But there's actually a lesser known case that I think is much more analogous for our purposes. It's called Goss v. Lopez. It's about a right to a public school education. It went to the Supreme Court just after Matthews. So it basically said when a student, so the Supreme Court basically said, excuse me, when a student is suspended from school or expelled, before that can happen, the student is entitled to notice of the suspension, a right to be heard on the suspension, and an unbiased decision maker to decide. Sorry, everybody. So, depending on the nature of the benefit, more or less of that process due is needed. So, I apologize. I don't know why that happened. I drink water all the time. So. Anyways, in summary, that's what this is about. Our youth are being allowed the due process when they're being terminated from shelter. So yeah, you can go to the next slide too, the Harthak, Erica. So again, what are the due process rights of youth who are in shelter or emergency shelter? The answer actually depends on the funding. So there are 2 major funding streams that affect youth, and there are actually 3, but we're going to talk about 2 first, and then we'll talk about 1 after. So a piece of legislation, it was called the HALT Act. It transformed how homeless services were funded in this country. it basically consolidated HUD's competitive grants programs. There was lots of different programs, but it consolidated into 2 specific programs. The first one is the Continuum of Care program, which Tori's going to be talking about soon. So the Continuum of Care program is basically, it's a community-wide effort to solve homelessness. So advocates, governments, entities, agencies, they sort of engage in a grants process to try and solve homelessness in a community-wide effort. The other huge program is called the Emergency Solutions Grants Program. So that's more of what we consider emergency shelter. It's a way to streamline access to housing and rapidly house people. Now, these 2 funding streams, they overlap a bit, but generally speaking, that's what they're doing. So in the HALT Act did all kinds of different things, but for our purposes today, that's the most important thing. And the second most important thing is it did 2 things as it pertains to youth. So when the HALT Act was passed, it was May 2009, and then there were rules, federal rules promulgated just after that in 2011 for the Continuum of Care program and for the Emergency Solutions Grants program. So one of the things it did, it redefined what the age youth are under the Act to include youth up to 25 years old. That was not true before that. So it was HUD's goal to adequately address transition aged youth and to include youth exiting foster care systems into permanent housing. So if anybody knows anything about in the youth homelessness space, people talk about this, that but the youth who leave foster care, it's basically a feeder system to the homeless system, to youth homelessness system. The statistics many people cite is that within a year of leaving foster care, 40% of those youth will become homeless. So this was HUD's attempt to try and address that issue. And the second thing it did, it said unaccompanied youth under 25 years age, or families with children and youth who don't otherwise qualify as homeless under this definition are eligible under this act as long as they meet other criteria. And one of those criteria was another federal definition of homelessness. So if they don't qualify under the HALT Act, but they can qualify, say, under the McKinney-Vento Act, which has a much more liberal definition of homelessness. So if they qualify there, they can qualify for services here. And they must meet other criteria, like they couldn't have had an ownership interest or at least within the last 60 days, experiencing persistent instability, and will continue to do so in the future. So, but as long as they meet those criteria, they can access these housing options. So yeah, so okay, I got you, Haley. I'm getting there. So what does it actually say about due process and termination of assistance? So these federal regulations that are passed actually talk about what due process is and what termination of assistance is. So in general, and I'm going to talk about the emergency solutions grants, and then I'll talk about continuum of care. So in general, if a program participant violates program requirements, the service provider may terminate the assistance in accordance with a formal process established by the service provider. So the service provider holds the key here with the process. They create the process. But the service provider must exercise judgment, examining all extenuating circumstances and determining when violations occur and what warrants an actual termination. And it should only be done in the most severe cases. So, and then what it talks about, and this is where Goss v. Lopez, I think, is very analogous. It's almost exactly like that. So it says, to terminate rental assistance or housing, the required formal process at a minimum must consist of written notice to the program participant containing a clear statement of the reasons for termination, a review of the decision in which the youth is given the opportunity to present written or oral objections before a person other than the person who made the decision or a supervisee. So no one who participated in the original termination decision. And then they must get prompt written notice of the final decision to the program participant. And this is also very important. So they must also hold the ability to provide further assistance in the future. So termination under this does not, the agency cannot just say they're not going to serve this person anymore. They should be able to get back in line if the termination is successful. And this is something we're going to hear about a little bit later about around youth being banned from shelters. So that's emergency solutions grants. The continuum of care is almost identical. It's literally almost, the verbiage is very close, except there's one major difference, and it's around the notice provision. So it says, so around the notice provision, it says providing the program participant with a written copy of the program rules and the termination process before the participant begins to receive assistance. So with notice, not only are they need notice of the violation, but before they receive services, they should have notice of the program rules and the termination process. So if they did not do that, then they would be in violation of the notice provision. So, okay, so I will pass to Tori now. I'm just to let her talk about how this is how it's affecting her community.
Thanks so much, John. One thing that I really want to emphasize and underscore is that these housing programs are absolutely essential to young people. It is really considered a housing of last resort. In order to even qualify for many of these housing programs, you have to be experiencing homelessness at the time you apply. So if folks are being terminated from these housing programs, they're most likely being terminated and being put back on the street. So it can be a really, really traumatic event for young people. And this class of folks are very, very vulnerable. So I am, excited that we have regulations and a statute that put in place a clear process that agencies are required to go through when terminating somebody from the program. But I'm disheartened to see in our community that that is not happening. So as I mentioned earlier, I work for Legal Services of Eastern Missouri, and my primary population is unaccompanied youth. A lot of my clients utilize these programs given their homeless status. And unfortunately, what we're seeing in our community is that a lot of folks are being terminated from these housing programs without any process at all. The regulation itself kind of sets out what that process is. But that is not being followed by the agencies, at least in our community, based on my experience. So I'm going to highlight one case that I'm working on with John and other folks at NHLC, give you a little bit of background about this particular client, and then kind of what our brainstorming has been looking like, because these are very novel issues for our community. There's not a lot of people looking at terminations of youth in housing. When we're often thinking about terminations from subsidized housing, it's often in the public housing context. Section 8, we're thinking of HUD and like your local housing authorities as the agencies that are administering these subsidies. In this case, it's local homeless service providers that are issuing these subsidies to young folks. And so there's kind of a lack of knowledge about what their obligations are under the law. So I'll get to it. So I unfortunately have had several clients that have been terminated from housing without any sort of process. The one that I'll highlight, I'm going to call her Anna. So Anna is a young person. She was 17 at the time that she entered this transitional living program here in our community. She was experiencing homelessness. She was doubled up, toggling between multiple households. She oftentimes would take employment that allowed her to take overnight shifts so that she had someplace safe to go during night. Anyways, she was accepted to a housing program. It was working out great for her. She had a friend. They had a falling out, and her friend unfortunately came to her apartment without her permission when she was not there, entered the apartment, forced herself into the apartment, and essentially took all of her clothing, her belongings, threw it outside. As a result of this, she got a phone call the next day, our client, and was basically told, you need to show up to the apartment complex pronto, collect your belongings, you're out of the program. So in this particular case, Anna had no other place to go. She had no trusted family members, adult supports, no one. She arrived to the apartment complex. The housing manager was there. Maintenance was already there, changing the locks on the unit. And our client tried to express her point of view, even get more information about what exactly happened since she wasn't at the apartment at the time this incident occurred, and essentially no one would listen to her. So as a result of that, she had to collect what belongings she could, which many of them had been destroyed and demolished, and collected her belongings and then kind of had to start afresh. One of the things that also will highlight is that these termination procedures not only protect young people from returning to homelessness, but they also really put in place safety mechanisms. What we know is that young people that are experiencing homelessness are subjected to higher rates of domestic violence, sexual violence, and that certainly was the case for my client as well. So not only was she not provided with any process, despite trying to object to the termination itself, was never provided anything in writing, no opportunity to explain her side of the story, wasn't even entirely clear why she was being terminated from the program for the conduct of another individual. So was essentially made homeless again. She was provided with no additional supports or resources to rehouse, no other opportunities to go into another housing program. The unfortunate thing about my client as well is that the individual that destroyed her belongings continued to harass her as well. So she was really put in a very, very unsafe position by losing her housing. So this is just one example of what we're seeing in our community. This particular housing complex or housing program was supported with COC funding. And so we've been kind of tossing around a lot of different legal theories, how to address this case. And obviously, there's a lot of different concerns. Your client priorities always come first, how they best want to proceed on a case, because our communities are small. They're often interacting with agencies that know one another. And so there's a lot of concern over retaliation or different agencies speaking with other folks of other homeless service providers and potentially blacklisting you from future programming with them. So these are all a lot of concerns that we deal with on the ground. So I'm just going to highlight kind of some of the legal theories that we've been brainstorming around. We have explored a private right of action, a 1983 private right of action to enforce the statute, because there is also a statutory requirement under the McKinney-Vento Act, and then it's further fleshed out in the COC regulations. I'm sure a lot of folks on this call who are attorneys know that those are notoriously really, really difficult for folks to prevail on. The courts historically have started to kind of narrow the ability for private citizens to enforce these statutes. So that is one thing that we've been exploring, but again, it's going to be a real challenge. Secondly, so the COC, or I don't want to get too much into the nitty-gritty, but agencies will accept the COC funding. Usually they have to sign a grant agreement either directly with HUD or what we call the collaborative applicant for these COCs. And so we're also exploring whether or not our client would have a right to enforce that grant agreement as a third-party beneficiary. And that's because those grant agreements include language that the agency is required to comply with federal law. And the regs are very clear that those grant agreements also have to include explicit language about these termination procedures as well. We would argue that our client is a clear beneficiary of these contracts. This money is being dispersed to an agency to serve young people like our client. There's also grievance processes too that you can go through with your local COC. What we're finding is that they're very varied among all the COCs. So it's been difficult to really kind of pinpoint what grievance processes are available, since the regulation and other guidance by HUD doesn't make explicitly clear what's required of the COCs when dealing with grievances and what sort of clear process they need to make available. But that's also something that we're exploring as well. So those are kind of some of the things that we've been looking at. Again, these are very novel issues. There's not a ton of people across the nation that are looking at these problems, and it's in large part because there's not a lot of people representing young folks in their community. So I'm excited to see that there's so many people that have joined us on this call that are interested in this issue. And we're always looking for more legal minds in the room to provide feedback or insights or their own expertise and knowledge, since, again, this is something that we're tackling for the first time.
Thanks, Tori. Much appreciated. And I just want to say, like, so this case you're talking about we're still working on this case. It's an ongoing case, and we've tried to settle this case very quickly and tried to negotiate, and we've really been stonewalled. So, anyways, I just wanted to add that. And one of the issues that happens is, because this youth is sent back into homelessness, we sort of lose touch with this person. So these, as you said early in your presentation, these are really important and they're necessary services. So I'm going to move on. I know we're probably pushing for time a little, so I'm going to move on and talk about the Runaway and Homeless Youth Act. So the Runaway and Homeless Youth Act is the largest piece of legislation that affects youth experiencing homelessness and provides millions of dollars in funding to FISB and its grantees. So this is in addition to the COC and the ESG, but this is the piece of legislation that was targeting trying to solve youth homelessness or trying to serve it. Anyways, the RIA is the definition, that's the acronym we use. So it was originally passed in 1974. It has been amended several times since its enactment. There's been significant changes. It's 2008, and then there was a final rule in 2017 with significant changes. So it provides the federal funding to emergency shelters, transitional living programs, other housing programs, targeting youth and young adults. So the funding provides the basis for the Runaway and Homeless Youth Program and the Family Youth and Services Bureau as part of DHHS. So there's hundreds of programs in nearly every jurisdiction in the country, including Puerto Rico, DC, and really other places as well. So these are hundreds of grantees. So the RIA made it the responsibility of the federal government to develop an accurate reporting system on the prevalence of youth homelessness. And it was to assist in the development of an effective system of care. This is exactly what Tori was talking about. An effective system of care, including prevention, aftercare services, short-term and long-term housing, and it should be outside the child welfare and the law enforcement system. So not putting youth in other types of custody. This should be outside of those systems. So you can go to the next slide, Erica. So the purpose of the RIA and grants program is to establish and strengthen community-based projects to provide runaway prevention, outreach, shelter, and transitional services to youth who have become homeless or at risk of homelessness. So there's two big housing programs they go to. So some of the money goes to street outreach programs, but we're not going to talk about that today. We're going to talk about the two housing programs where the main funding goes for where youth are being housed. So the first one is a basic center program. It provides temporary shelter for minors experiencing homelessness up to 21 days with counseling, therapeutic, and family interventions, and access to educational services. And really the main goal of a basic center is reunification with a family or a legal guardian, but that is not always possible for various reasons. And 21 days ticks very quickly, and often youth have, minors really, kids have nowhere to go. The second program, and maybe the largest one, is the transitional living program. This provides longer-term housing, which can include host family homes, group homes, supervised apartments owned or operated by the agency for transition-aged youth 16 to 22 years old with supportive services. So some states will define transition-age youth up to 24 and up to their 25th birthday. So if that is true in their state, then these programs will cover those youth up to their 25th birthday. So what are the due process rights of youth under RIA? So there's good news and there's bad news. So under RIA, there is no formal process. The regulations don't talk about any formal process. The statute, there is no process around due process. But in 2017, there was a new rule promulgated. And I think it was to solve this issue, or at least address the issue. So it talks about safe and appropriate exits. So basically, grantees shall ensure that youth who have safe and appropriate exits when leaving the program. Each grantee shall report data on the type of exit experienced by each young person departing from a transitional living program or basic center program. So in the regulations, it actually defines what these are, or gives concrete examples. They're not exhaustive lists, but they're examples of what they are. So basically, it says it's the safe and appropriate means the setting that reflects the achievement of the intended purposes of the basic center and the transitional living programs. And it says safe and appropriate exits are exits to a private residence of a parent, guardian, another relative, or another adult that has the youth's best interest in mind. So this is basically a reunification. To another residential program if the youth's transition to the other residential program is consistent with the youth's needs, or to an independent living if consistent with the youth's needs and abilities. And then it goes on to say what safe and appropriate exits are not. So they are not exits to the street, which we found that this happens quite a bit. Their safe and appropriate exits are not to a locked correctional facility. So if they're in a youth program, they're in the transitional living program, and they end up in jail, that would not be a safe and appropriate exit. To another residential program, if the youth transition to the other residential program is inconsistent with the youth's needs, or to an unknown or unspecified other living situation. So each grantee, each agency is held to a standard that must be 90% effective in providing safe and appropriate exits for youth and young adults. So I think this is FISB's way of trying to keep grantees and hold their feet to the fire, because 90% effective is really not a thing. It really should be 100%. In the regs, it says all youth should have a safe and appropriate exit. So anyways, I'm going to pass to Liz now, and she's going to talk about what's happening in her community. And she's sort of had all of these programs, COC, ESG, and RIA. They all sort of she's come in contact with all of them. So I'm going to pass to you. You take it away, Liz.
Hi, everyone. It's Liz again from Southern Legal Center for Youth. So I really stumbled across this issue, not really, it wasn't planned. You know, my plans were to provide civil legal aid support to young people experiencing homelessness across a number of different areas. But this matter really came to my attention when I was talking to service providers across the South, who said, when I asked them, like, what's going on in your community, they said, as if it was nothing, and that it was something that happened all the time. Oh, young people just keep getting banned from the shelters. And I thought to myself, that just really doesn't sound right, because I'd heard about John's work at the NHLC, and I'd watched his webinar, and so it was just giving red flags a little bit. So I contacted him, and he said, this is actually pretty bad. And this is something that we should probably look into. But some of the challenges have been that a lot of the rights that young people have in shelter are tied to whether or not the organization gets public funding. So what we're seeing is that these bans, and I'm going to outline some of the other issues apart from bans, these bans are happening at shelters who are publicly funded and who are not publicly funded, so who rely on private money. So just as an aside, something that I am thinking about, and you all can think about too, where you live in the South or in the city that you live, is how could we develop some systemic change around this issue? Like, how could we get city code ordinances passed, or county code ordinances, or even state legislation passed that gives young people their rights under the federal law, but at our state or local level? So that's something that I'm thinking about. But back to kind of the issues that I've been seeing, you know, some of you might be like, well, you know, if a young person like brings a weapon into a shelter, sure, they should probably be like banned for like a certain period of time. But we're not talking about that. We're talking about young people who the shelter staff don't like, who they have said talk back. Maybe the young person has got into like a little bit of a fight with another young person and there's like some attitudes there. Or we've heard things like the young people have been banned when they have been unmedicated for a mental health issue and they've been in shelter. We've also heard things like, apart from the bans, we've heard that young people are just like terminated, like basically they're asked to leave, like pack your stuff and get out at 7 o'clock in the morning. Sometimes if they wake up late or they come back from curfew late, like they might be banned or they might be terminated on the spot. And some of the other issues that we've been seeing are they've actually been forced to sleep on the floor on a mat for weeks at a time. Some of them from a few days at a time to weeks at a time with no bedding. So, and also there's cleanliness issues at the shelters. So they're sleeping on floors that basically haven't been cleaned for weeks at a time as part of kind of standard intake procedures. Some of the other issues are deeply concerning around discrimination. So one young person told me that they were made to sleep on the floor for longer because they'd just been out, they'd just gotten out of jail. So they were told, we need to keep you on the floor for longer to monitor you because you just got out of jail. But actually this young person was lucky to even get into the shelter because we've heard that they also discriminate against young people who have just been in jail by not allowing them to stay at the shelter. So also we've heard that young people have not been allowed to come stay at the shelter if they have behavioral health issues and they're not medicated. And some really concerning things around gender discrimination as well, around really kind of disturbing practices at the shelters, not using young people's correct pronouns, making them sleep in kind of gender specific rooms, even though they tell the community that they have a special room for trans and non-binary clients. Like that is kind of a big issue that we're seeing. And also concerningly and just kind of crazily, young people with severe food allergies, like peanut allergies, are not given food that has no peanuts in it. So for example, peanut butter and jelly sandwiches are given for lunches, and then a lot of snacks are peanut based, and the young people with severe peanut allergies are told basically like, tough luck, like you're not going to eat if you don't eat this. So yeah, I just wanted to raise up those issues, and you know, we've got some young people in the South who are looking to explore kind of their options around some of these things that have happened to them, and we'd really like to chat more about what that might look like with you all.
Thanks, Liz. And I'd just like to say too, so we did a site visit there too, and it was sort of an amazing site visit, and literally 100% of the youth, nearly 100% of the youth were of color, and there was and this is very true in the youth homelessness space. Disproportionately, youth are of color and of LGBTQ status. So the discrimination is a major issue here, and we didn't get into a lot of the stats around youth homelessness, but or even the Runaway and Homeless Youth Act, but it is very clear that there should be no discrimination at all under the act, and there is actually supposed to be they're using a positive youth development. So these things about talking back and being thrown out of shelter for these things is really not appropriate. So I just wanted to put a fine tune on that. So
Oh, John, you're on mute accidentally, I think.
I don't know how that happened. I think I probably did it on myself, but anyways, thanks, Katie. So I want to also talk a little bit. So so Liz and Tori, I think, are a bit exceptional because they've been looking at this issue and finding this issue and really listening to youth about this issue. But we have we have found that this issue is probably much more widespread than we even know. So we came up with a survey so that we could talk to youth and find out what their experiences are with youth homelessness. So we surveyed youth in California, Washington, Oregon, Pennsylvania, Delaware, even Georgia and Missouri. We did, and so we asked this question. We asked a lot of questions, but this one question I think is important here for our purposes is, have you been asked to leave or been terminated, exited from one of the housing programs? And almost 41% of the youth said they had. And if you extrapolate that over thousands and thousands of youth across the country, that is, and these are not statistically significant, these are just preliminary results, but still, if you extrapolate that, that is a lot of youth. And then when you dig deeper into the data, are people receiving a process? The answer mostly no, like 60 to 70%. Are what is happening with youth? They're being sent to the streets. Basically what is happening is inappropriate on a national level. And the second, Erica just went to the next slide. So we also did a survey of providers, and we actually had help from pro bono firms from Alston & Bird and Littler. They did an amazing job for us. We would never have had this kind of response if it wasn't for them. So we had about 70, I think we had, it just says 73 responses, but we've had up to 75 at this point. But so we asked youth providers, and this is specifically Runaway and Homeless Youth Act youth providers who are supposed to have safe and appropriate exits. We asked them this question: must the youth have to have a safe and appropriate placement to go if terminated? And 33% of them said no. I mean, this is from the youth providers. So we found this is pretty alarming, that all of the youth in this scenario should have a safe and appropriate exit, and they did not. So we think this issue is much more widespread than we even thought. So I just wanted to point that out. I think we're going to go to the last slide, I think. Because of this, one of my goals was to create awareness around this issue with people like Liz and Tori, so we wrote up a practice guide, Basic Rights of Youth in Shelter. So it's a practice guide. It's, many youth advocates, like we've been talking about, do not know how these rights exist. So we wrote this practice guide. It's sort of an exhaustive research on the HALT Act, on due process, and if youth might have a property interest in this, if there is an actual right to shelter. So that's something else to be said, as well as most youth or even adults across the country do not have a right to shelter. There is a right to shelter in New York, and in DC has a right to shelter when the temperature is too low or too high. And in Massachusetts, there's a right to shelter for families, but most youth, adults across the country have no right to shelter. So that's why these due process rights are so important. And so we also have practice tips in the guide, and some of the things Tori talked about. And so, yeah, so that's basically it. That's it for me. I'll pass to Katie, and if anybody has any questions, we can try and answer them.
Yes, John, we do have a question going back to the survey results. In the provider survey, did the people who answered no, like, was there any explanation for that in some of the other questions, or just like, did you get a sense of when they're saying no, like, did they even realize that there was these rights in the law, or this requirement in the law? More elaboration on that.
Yeah, no, that's a really good question, actually, and that's part of what we're trying to do, is create awareness around this issue. So I think the answer to that question is they have no idea. They don't know what the regs say. They don't know that is what they're supposed to be doing. That was my sort of takeaway. I mean, people didn't really go into specifics on why they said there was no safe and appropriate exits, but they basically, the answer to a lot of the questions was, we plan for exits from intake. That's basically what they say. And so I don't even think they think exiting a youth is sort of inappropriate in this situation. So, I mean, that's a really good question. I think And that's part of, Tori and I have been talking about sort of, and you, Katie, and even Liz, because Liz mentioned it too, is like sort of creating model grievance procedures, model termination procedures for these programs to sort of create awareness around this issue. So yeah, to answer your question, I don't think they even know that they're
And
supposed to be.
Katie, just to kind of add to that, that particular question was asked as a yes or no answer, so they didn't actually have to go any further in depth. But one thing that John and I are currently working on is further distilling all of the information that we got from both of these surveys, so that we can move forward trying to figure out how we can craft something that makes sense, for a model moving forward.
And yeah, and actually I meant to say this, but I forgot, is that Erica and I just, we just got accepted to write something for the Maine Law Journal, I think it's called, around this issue. And we're going to use all these survey results. We're hopefully going to do a little more surveys as well. And we're going to use this as a sort of a model to create awareness and write something specific about it.
That is awesome. So I don't see any other questions in the chat, although I would say we probably do have time for one more. So if you think of something as I am going over some of these pro bono opportunities, please don't hesitate, like go ahead and put it in the chat. But I just wanted to kind of highlight some of the pro bono opportunities, both of, from the presentation today. I think you kind of got the idea that as we're presenting this specifically because this is sort of a new area. There isn't a lot, like there's obviously not case law about it yet. And we're really kind of dipping our toe in the water here of trying to figure out a way to really protect the rights of youth in shelter. And we've got a couple jurisdictions where, there's some potential litigation brewing, but certainly also need for research. So we are hoping by kind of giving you all a little basis and background in the law and the legal issues, when you see a pro bono alert come around related to this, you at least have some knowledge and can feel more comfortable, hopefully, jumping in here. I will also say that we've got a few other things on the youth team at the Law Center that we're currently looking for help with. One thing that has come up recently, and actually one thing that can prevent some of the issues that all of our presenters today have seen in shelters, is when youth actually help design and co-design the shelter programs and services. And there's a lot of push from the federal funding to ensure that there are youth action boards, youth leadership councils, youth consultants who are participating and getting their voice heard when it comes to designing the programs and services that they need, or reforming the programs and services that currently exist. Now, a lot of those youth are then getting paid to do this work, which often puts them into a kind of limbo of what their status is. Some organizations, they have contracts with these youth to pay them as consultants. Some organizations have contracts with these youth and are paying them as consultants, but the way that they're actually going about that whole process kind of skirts the line between whether someone is an employee or consultant. Like if the organization is really directing the work of the youth, suddenly we've got a situation where are they really independent contractors under labor law? So we had a wonderful project from the folks at Littler to actually do a 50-state survey of, independent contractor and employee laws, and applying them specifically to different scenarios when it comes to sort of these youth projects that a lot of organizations are doing. Now, we've got all that information. We're working on a youth compensation legal guide, which I will say that if there's anyone on the call who is a contract law expert, or who might have some experience in even corporate law, as far as like really small micro businesses, a lot of young people are forming their own LLCs to do this work as consultants. And so we're coming up with a legal guide. We've already got sort of a tax section. We've got a public benefits section, like the effect on these kind of payments on folks' public benefits. But we're really looking for more help on the contract side and the corporate law side. Now, we also have a variety of young people who have run into problems with organizations that they've worked with and are looking for some consultation as to whether or not they have any rights, based on contracts or potential violations of contracts, understanding whether they are appropriately, determined to be a contractor. So I think, that is something that we are also looking for. So if you have any interest in that, please let us know. We are looking for some litigation support for a case that we're working on in Maine, having to do with racial discrimination in land use and zoning. That's something that I can share much more about. We will put out sort of a pro bono alert describing this opportunity more, but if that's something that you're interested in, please let me know. We have endless research opportunities for our index on youth homelessness. There's probably some folks on the call who have participated in pro bono opportunities around the index, researching state policy interventions for unhoused youth. We are also sort of expanding that to include federal and tribal policies. So again, that is something that is almost always available year round. One thing that we started doing is adding the territories. So we're researching all of our metrics as they apply to the US territories. And then finally, I just want to highlight McKinney-Vento education rights. This is another one, like historically, the Law Center has been very involved in these cases. There was maybe like a trend where it seemed like most states have kind of gotten, a little better about ensuring that unhoused students are able to access an equal education to house students. We have found that there are a couple jurisdictions now where school districts are slipping on their enforcement of those rights. And there are some wonderful advocates who are trying to pursue, the enforcement of those rights for students that they represent. So we've had some excellent pro bono help already in kind of researching the potential of strengthening the potential of a 1983 civil rights claim under the Act. But we imagine as we move forward with potential litigation, we'll be looking for pro bono partners. Okay, so that's a long explanation of some of our pro bono opportunities. I think we can go to the next slide with the contact information. I've seen in the chat, we will have a copy of the slideshow available with the link to the practice guide and all this contact information. One really exciting thing I do want to share is that after, we miss our pro bono director, Carlton Martin, so much, but we are very pleased to announce that we're going to have a new pro bono coordinator joining us next week. So there will be more information about that and an introduction to that person. And yeah, as far as any of sort of these pro bono opportunities, you can reach out to me directly. My email is there. If you are specifically interested in the youth shelter and housing, feel free to reach out directly to John. If you are interested in getting more involved with the stuff that's going on in Missouri, Tori is a great contact. If you are a law firm in the South that is interested in supporting the work that Liz is doing at Southern Legal Center for Youth, that would be most welcome. And if you are interested in joining HALT or you need more information about HALT, please reach out to Jennifer Toth-Clary. Her email address is there and she can give you more information about that. So I'm just going to check the chat one more time to make sure I'm not missing anything. I did see some folks sent me direct messages. I will make sure I copy and paste those email addresses that were shared and reach out to you. So thank you all again for joining us. Just let me know for the presenters if there was anything else, but otherwise I think we can end a few minutes early.
No, nothing else for me, Katie. Just that if anybody's interested in this work at all, in research or any litigation, reach out to me and we'll talk.
Amazing. Thanks all. Thanks for spending this hour with us. We really appreciate you all.